Welcome to the New York State Association of School Business Officials webinar. Today's program is Get Set, Development of Plans, Specifications, and Bond Documents. Your host for today is Donna Clement, Director of Professional Development with New York State ASBO. Operator assistance is available at any time during this conference by pressing #. A question and answer session will follow the presentation. You may send chat questions during the presentation using the chat window indicated by a speech bubble icon located to the right of the presentation. Please address chat questions to the Q&A group using a drop-down list located at the bottom of the chat window. I will now turn the call over to our host. Donna, please begin.
Thank you, Michelle, and welcome everyone to our webinar. This is the second in our series in the online course on capital construction projects. And if you're taking the course, thank you, and those who aren't, and we're glad that you joined us today. And our speaker today is Marianne Sadowski, who's very well versed in construction project information and specifically on the part that we are discussing, developing plans, specifications, and bid documents. So Marianne, thank you so much for being with us today, and we really look forward to the good information you're going to share.
No, thank you for having me. Are we ready?
Yes.
Hello, everybody. Hi, Kathleen. How are you today? Oh, they can all speak back, correct?
No.
Or no? Oh.
No.
Well, anyway, hi, Kathleen. I see that there are several people here who are sitting in business offices, and I hope that you all enjoy the next 75 minutes. I'm going to try not to bore you to tears. Construction tends to be somewhat of a dry topic. Just to give those of you who do not know me a little bit of background, I'm a partner at Ingram & Smith. My primary responsibility is construction and commercial-related matters. I head up our team of attorneys here. Since I arrived at Ingram & Smith, I have been answering questions concerning construction and have been involved from prior to a bond referendum through the end of the bond referendum. And I know that for those of you who participated in the first piece of this presented by Marty Geiger on bond referenda, I tend to get involved prior to that time, although my presentation is supposed to be from that point forward. And then post this webinar, there will be another webinar presented by an individual on what happens during the construction project. I'm going to try to stick with my topic. For those of you who know me, that tends to be a difficult task. Your bond referendum has now passed, and what do you do? So I've just uploaded a slide which really gives you an overview of the school district construction process. And as I said, Marty spoke about bond referendum. There is, as you all know, another way to fund a school district construction project, and that is through the school budget itself. Those tend to be smaller projects. Bond referenda tend to be multi-million-dollar projects which will encompass a number of different issues, usually district-wide or technology projects, that sort of thing. You should have a licensed architect or engineer to design your project. Once you have a project, the plans and specs developed by the architect and engineer need to be approved by the New York State Education Department. Once you receive approval of those plans and specs, you're going to advertise for competitive bids and utilize the Wicks law. And then you're going to award your contract to the lowest responsible bidder. That's the overview. And we're going to go through each of those in a lot of detail over the course of the next 75 minutes. One of the things that I will tell all of you is that if you have any questions during the course of the presentation, please ask them as I go along. It's not a problem for me at all, and it makes it a little bit more interesting than just listening to my voice for 75 minutes. So please feel free to use the chat that is before you on your screen, and I'd be happy to answer questions as we go along. So if you've already passed a bond referendum, you should have engaged the services of an architect or engineer to assist you in the planning of that project. one of the important things that an architect and an engineer help school districts do prior to a bond referendum is define the scope clearly so that your voters know what they're voting on. And secondly, to come up with an estimate of the project budget so that you can go out to your voters with a realistic number which has enough space in it in the event that bids come in over budget. There's an architect down here on the island who there are what are called hard and soft costs in a project. And the hard costs are the actual labor and materials that are required to build the project, and then there are what we call soft costs, which include the cost of an architect or engineer, the cost of a construction manager, costs of bond counsel, and then a percentage is usually the way they do it for to take into account contingencies in the event that bids come in over budget if there are changes along the way. My recommendation to our clients is that you really need to look at that number very, very carefully. And as I started to say, there's an architect on the island here. I'm from Long Island in Hauppauge, who will add in only about 4% for those soft costs, including contingencies. And the problem when you make that number too small is if you are in the unfortunate circumstance of having your bids come in over budget, in order to spend more money than the voters have authorized, you need to go back out to the voters for additional authorization, which, as I'm sure you all are aware, is not really a very preferable thing to do. So when you're looking at the estimates prepared by the architect for the bond, you really should be looking at those things to make sure that there is enough contingency built into those soft costs so that you don't find yourself in the unfortunate position of having to go back out for a second bond referendum or vote. And I have been involved in a couple, not a lot, of situations where that has exactly happened, where the architect has sorely underestimated the cost of the bond, and the district had to go back out. Usually when that happens, the architect is no longer the district's architect, and they've hired somebody new. But just be careful in that vein. Secondly, you should have decided if you're going to engage the services of a construction manager and whether or not you want to engage that construction manager prior to the bond referendum being put up for a vote or after. There is good and bad with both. In the event that you decide to utilize the services of a construction manager prior to the vote, one of the things that and I'm going to refer to a construction manager as a CM, one of the things that the CM can do is come up with its own estimate, and then the architect and the construction manager can reconcile their two estimates so that you've got a second set of eyes looking at the numbers that are being put forth to your voters. If you choose not to hire a construction manager until after the bond referendum is passed, you'll save some money because typically construction managers will look for a fee prior to the bond. Some architects and engineers will not. They'll take it as their risk that the bond will be approved. And if they are going to charge you any money pre-bond, it tends to be nominal. And one of the tips that I can give you is if an architect or an engineer or a construction manager wishes to charge you for their pre-bond services, and this is more directed at an architect-engineer contract, then what you should be looking for is a credit of that money back if the bond passes. Most architects and engineers will submit a proposal which is based upon a percentage of the cost of construction, although that's changing a little bit these days. So if you can get that money credited back into the percentage fee that's actually going to be charged you once the projects become approved projects by the voters, that'll help you reduce some of your costs. And the last bullet is just that you really should have identified the projects to be accomplished if the bond passes. A lot of times I will get questions concerning can I add more projects to to the bond, and I always defer to bond counsel because they have written the bond resolution. You want that scope of work that's included in the bond referendum to give you enough leeway that if you are in a position to do some additional projects, that they will fit within the authorization that has been given you. You'll have to excuse me. I'm getting over a cold, so I may cough a little bit during the course of the presentation. So now you're ready to design the project. One of the questions that I always get is, can I engage the services of the architect to provide me with a complete design prior to the authorization of the voters? And the technical answer to that question is no, you may not. The law permits you to engage the architect or engineer prior to the bond referendum to prepare preliminary plans and specs. And SED, the New York State Education Department, has relaxed that somewhat. But technically you are not permitted to prepare final plans and specs until after the bond is approved. So first and foremost, the project must be designed by a licensed architect or engineer. In New York State, the engineering firms that tend to submit proposals on projects are of two types. The first being an all-service architectural or engineering firm, or an architectural or engineering firm which subconsults out the mechanical, electrical, plumbing, site work to a subconsultant, i.e., another licensed professional. And I see that many problems that I've seen in the course of litigating against architects and engineers comes from the failure of the architect or engineer to properly coordinate the drawings and documents it gets from its consultants with the documents that have been developed in-house. So there is a benefit to having what I call an all-service architectural/engineering firm who's developing your plans and specs, because if everything is being done in-house, the likelihood that there will be a conflict between those drawings is lessened when everybody's in-house. So during the course of the design, there are several phases of design which are referenced in the industry, and the first is called schematic design, and that's really floor plans and sketches of what you would like your project to look like. The second phase is called design development, and that's when you start deciding what types of materials to be used, and the architect fills in the blanks. And it's like painting a portrait is the way I like to illustrate the point. You start out with just a basic drawing, and then it gets filled in somewhat at design development. And then once all of those decisions have been made, the architect proceeds into what's called construction documents. And all the I's are dotted and the T's are crossed, hopefully. A complete set of plans and specs is developed and submitted to the New York State Education Department. One of the things that I always caution boards of education about, and business officials and superintendents, is that along each of those phases of work, the architect is supposed to get the approval of the owner, and you, school districts, are the owners in this case. And a lot of times what I've seen and heard from my clients is that approval is not done formally as we would think of it, where the architect or engineer will make a presentation and get written approval, so to speak, or a board vote saying, yes, that's how we want you to proceed. What happens as a practical matter is the architect or engineer will complete its design through each of the phases I just described and walk into either the business official's office or the superintendent's office and say, I need you to initial these documents. That's something that architects and engineers believe constitutes approval. I tend to disagree vociferously. The proper course of action is for the architect to put together its schematic design and make a presentation and say, this is what we have, this is where we're going, is that what you want, do you want me to do this differently? I've seen only one architect do this well. where they've actually had proposed plans and specs on a board and came with a red pen. And as each of the comments were given by the team of individuals who were appointed to review these things, and in this case there was a capital projects committee, which included board members, administration, and other sundry officials and individuals. And then the architect would take that back, having marked up what he put together, and come back with all of those things incorporated or not incorporated with an explanation why, and then solicited the approval of the owner, be it the superintendent, the board, or the business official. So just be careful if somebody from the engineering or architectural firm comes in and says, I need you to sign these things. You really should know what you're signing and why you're signing them. Because I've had architects and engineers in the litigation arena waive that initialing or signature as quote-unquote approval under the requirements of their contract. So they've completed each of the design elements. They're ready to submit the documents to SED. And you say, great, I can go forward and I've got a project and I'm going to be building this in a month. Well, for those of you who have been around for a number of years, the projected wait time at SED at one point in time was approximately 26 weeks. The website is now saying it's 4 to 12 weeks, but 12 weeks is still a long time to wait. So if you're looking to accomplish, for example, a roofing project over the summer months, make sure that your architect or engineer is putting together the project in a timely fashion so that you're not going out to bid in June, but rather going out to bid in February or March. You get the benefit of better prices when you do that, especially since most school district projects are done during the summer, at least major school district projects are done in the summertime. If you're just going out to bid in June, most of the contractors in the area have secured their work for the summer, and prices will be higher. And you may not get a lot of the better contractors bidding on your projects because they've already gotten their bulk of work for the summer. So remember, as you go along the planning of this of any project, to keep that in mind. The best time for a summer project to proceed is for the project to be bid in the winter or early spring at the latest. And if you need to do it at that time, that means you've got to get your documents up to SED prior to, let's say, Thanksgiving, if the timeline stays as it is, because there is no telling. Those timelines change all the time. There may be an influx of projects at a particular time of the year, and you don't want to be behind the eight ball because it's first come, first serve. So as your projects go in, that's how they will be reviewed. SED does have, or did have, I believe they still have, an accelerated process for smaller projects. My recommendation is you call your project architect at SED so that you can determine what the wait time is and whether or not there still exists a it's called fast track, and if not, how long your wait will be. Secondly, and this is on the aid side of things, as you are all aware, there is building aid for most construction projects. If you're doing a standalone site work project, it is not eligible for building aid. However, if you tie that site work project to a renovation project within a building, it is eligible for aid. And I've seen site work projects get attached to toilet room renovations that total about $20,000, and the site work project is $1 million, $2 million. So that's just a little tip for you in terms of maximizing your state aid. If you have a standalone site work project, try and do another project with it that is aidable so that the site work project will be aidable as well. I'm looking. Nobody wants to ask questions today. I know the Super Bowl was yesterday, but please, if you have any questions as I go along, feel free to send me a message, and I'd be happy to answer them. So now we get to what is submitted to SED. Well, obviously, we're all familiar with the drawings that architects develop. But along with those drawings is what's called a project manual or a project specification book. And that includes a number of documents. It tends to be a thick document, usually a ream of paper or more. And I will tell you that a third of that project manual is a legal document, not a technical document, and it will bind you in the event you encounter problems during construction. Most of Ingram & Smith's clients will have their architects or engineers send us the project manual for review, which makes me very happy because the one-third of the project manual that is a legal document is generally prepared or included by your architect, who is not a lawyer. There are standard form documents that are used in the construction industry. They're called AIA documents, and AIA stands for the American Institute of Architects. And guess who developed those documents? Architects and their counsel and contractors. As owners, you have not really had a say in what is in there, and no big surprise, the documents that are put out by the AIA tend to be very architect and contractor biased, not owner protective. So I recommend that if you have a project going out to bid, that you have the project, or you have a project going out to bid, that you have the project manual reviewed by counsel to ensure that you're being protected correctly within the document. And one of the things I laugh about is contractors, when they, and we'll get to this in a minute, when they pick up their bid specs, they never read the project. They never read the front third of the book. They go right to the technical specifications and they go right to the drawings. But the minute there's a problem, it's like the Bible. They waive it, they've read it, they just go with it, and if there are any inconsistencies or issues in there that are not protective of you, it's going to be your problem, not the architects, not the construction manager, and not the contractor. So I always recommend that those project manuals be reviewed by counsel, and not to look at the technical specifications, but to look at the provisions that are included in the, what we call in the industry, the front-end documents, which include the notice to bidders, instructions to bidders, the owner-contractor agreement, the general conditions of the contract for construction, and then there's a whole section called Division 0, which includes a number of items that are legal items that really should be developed in conjunction with counsel. So I've kind of gone through what is contained in the project manual. Obviously, there's a form of agreement, and the general conditions is typically about a 70-page document which outlines the rights and responsibilities of the owner and the contractor. One of the things that's required to be in the project manual is the State Education Department has, pursuant to 155.5 of the Commissioner's Regulations, very specific provisions that are required to be included in the project manual. And they generally deal with safety and how project areas are separated from the building if it's going to be used during construction. And if you visit SED's website, at the facilities planning section, there is a specific tab which will show you what those required conditions of contract are, so that you can ensure that your architect has included them in the project manual, and that is if your attorney is not reviewing the project manual, because we all know that they have to be in there. One of the things that I always recommend is that those required provisions be maintained separately in the project manual, so that when SED reviews the project, they see them right away. Next is obviously the technical specifications for the project, which really will define the types of materials that are being asked to be used, how installation is to be performed, whether or not any warranties are to be issued with that particular type of material, and the like. One of the misconceptions in the industry is that you are required to include two different types of material in the project manual if you're asking for a specific type of material. For example, a roof. If you're doing a roof replacement project, there is a belief that you have to indicate at least two manufacturers of a roofing system, and that's just not true. What the law requires is that the contract between the owner and the contractor include a provision for equivalents or substitutions. So you can specify a Carlisle roof, but you have to have a provision that says, if you are not going to supply me with a Carlisle roof, you must meet the following tests for us to approve your equivalent product. So there has to be an ability for the bidder to provide you with an equivalent product, and I like to see a process as to how that equivalent product is going to be reviewed by the architect or engineer. And that typically falls in the technical specifications for the project, although within the general conditions there should be a statement as to how equivalents or substitutions are going to be treated. At the beginning of the book, and I'm going a little bit out of order, is your advertisement for bids. One of the things that you cannot put in the bid requirements for bidders is that a pre-bid conference be mandatory. You can recommend that bidders come to a site visit, but you cannot dictate that they come. So you're going to be looking in your notice to bidders and elsewhere in the project manual for any statement about a pre-bid walkthrough of the project, and you need to make sure that that is not a mandatory walkthrough because the law does not permit it to be a mandatory walkthrough. Secondly, I've seen architects, the law requires that when a public entity like a school district goes out to bid, that those bids are valid for 45 days, and that if you have not awarded the bid within 45 days, a bidder has the right to withdraw its bid. Some architects and engineers extend that time requirement to 60 days. That is not permitted under the law. You are only permitted to keep bids open for 45 days. You can ask the vendors if you're not going to meet that time frame, if their bid is still good, because it is the bidder's choice as to whether or not it will withdraw its bid. But you cannot require that they keep their bids open for more than 60 days. Another thing that I see very frequently in project manuals is a statement that if a bidder submits his bid, that it's not permitted to withdraw it prior to 45 days. And that is generally true, except for General Municipal Law, Section 103, Subdivision 11, permits a bidder to withdraw its bid if it has made a mistake in its calculation of the bid price. And if you have a situation where a bidder is seeking to withdraw its bid, you should contact your attorney to see if it should be accepted or not. The instructions to bidders is a section that tends to have similar provisions to those contained in the general conditions. My concern with instructions to bidders, and one of the things that I review very carefully when I'm reviewing a project manual, is to make sure that what is contained in the instructions to bidders is not in conflict with what is in the general conditions of the contract for construction. And they typically are not. Sometimes it's redundant. My rule is say it once and say it well. Don't say it 500 times. Say it once and say it well. For every public works contract, you're supposed to receive from the Department of Labor, I'm not using my highlighter or pointer or anything here, a prevailing wage rate schedule, which is supplied by the Department of Labor. You are not supposed to be going out to bid unless the prevailing wage rate schedule is included with the project manual. And lastly, the bid proposal form, which sets forth a space for the bidder to include its bid price for the work being solicited. I'm going to try to stay away from some of the things that are going to going to be covered in the next presentation, the next webinar. But one of the things in the bid proposal form, which I think is important, is that I've had several times circumstances where the bid proposal form seeks a base bid for certain work and then alternates, which is, for example, you're doing a flooring project and the base bid is VCT tile, and you're asking the bidder to submit an alternate price for terrazzo flooring. That's fine. That is a perfectly appropriate alternate. I've also seen projects where the bid proposal form is base bid 1, give me a Carlisle roof. Base bid 2, give me a Firestone roof. Base bid 3, give me a Manville roof. That is an impermissible bid proposal form because it makes the bid proprietary, and as I said earlier, you're required to have an equivalent clause in your bid spec, and the way that that type of bid is structured would give the bidder an indication that it cannot substitute the specified product for any other product because it's contained in another base bid. So just be very, very careful on the bid proposal forms that the alternates and the base bids are set up correctly. There are also times when there's a good reason to do several base bids. You want to separate out from a renovation project the roof, the walls, and leave the rest of the general construction together. You do have the right to set up a bid proposal form where you give yourself the ability to award one by itself, different combinations of 3 or 4 bids together, and or a total award of bid. But you have to be very careful that the language that you include in the bid spec and on the bid proposal form gives you the right to award any combination of several different base bids. And I've litigated a number of cases where that was exactly the issue at hand. So just make sure that if you're looking to do that, again, if counsel reviews it, they can come up with language if it's not already in there, and or ensure that the language that you need to have is properly included in the documents. So now I'm going to go through some of the notable provisions that should be contained in a project manual, and there are several. The first is a performance bond and a payment bond for the project. And I'm going to first indicate the difference between the two. A performance bond is a bond that is issued by an insurance company, known as a surety in this industry, and it is to secure the performance of the contractor, so that if the contractor fails to meet its obligations and perform its contract work, you have a third-party entity to go to and to look to for the project to be completed. That's called a performance bond. A payment bond is very different than a performance bond. A payment bond is implemented to ensure that the contractor that you have hired is paying its subcontractors and or material suppliers. So if I am a manufacturer of brick and I supply brick to your project and I have not been paid by the contractor for that work, then I have the ability to go to a third-party insurance company and say, hey, you said this guy would pay me, and he hasn't paid me, and therefore I'm looking to you to get paid. And that's what a payment bond is. In the AIA standard form documents, there are no specific requirements for types of performance and or payment bonds. What I've seen at a bare minimum is that the insurance company that's going to write the bond be licensed in the state of New York. And what I like to do is I like to ratchet up the requirements and I'll explain why, so that not only when I'm reviewing a project manual, do I require that the insurer be licensed in the state of New York, but I also require that they have a certain minimum rating. And the governing body over insurance companies in the nation is AM Best. So I include in the requirements that the contractor have an AM Best rating of at least A minus with a financial rating of 7. And the reason for that is that just about anybody can get a performance bond or a payment bond. As those ratings go up for the insurance companies that write bonds, the reason that the ratings are high is because they have a high success rate in terms of not having losses. And the reason that they have a high success rate in not having losses is that they, if they are issuing a bond, have required the contractors to jump through a whole host of hoops. They cannot simply send in an application and get a bond. They have to demonstrate that they themselves are financially stable, that they have enough of a workforce to complete projects that they are bidding on. So I really recommend that you have some requirements in terms of the type of bonding company that will be writing the bonds for the projects. And I've now used 3 different terms. I know that: insurance company, surety, and bonding company. They're all the same thing. It's an insurance company that writes performance bonds. So be very careful that there is language in your project manual or bid specifications which requires some higher level of rating from the bonding company, because that will help you get a contractor who is more financially stable and has demonstrated success over the course of a number of years, instead of somebody who just sends in an application to Joe Blow bonding company and gets a bond. Secondly, the insurance requirements for a construction project are very important. And I'm going to skip to the bottom tab, which is whatever requirements you require for your contractor. If they are going to be utilizing subcontractors on the project, the subcontractor should be required to have the same type of insurance requirements. So the first bullet is, I'm going to test out the pointer. The first bullet is workers' comp, unemployment insurance, and automobile, all typical things that a contractor should have. The second is a little bit more complicated, not the commercial general liability insurance or excess liability, also known as umbrella coverage. Those 2 types of insurance most people are familiar with. Commercial general liability is written to insure against personal injury or property damage. And excess liability covers over and above whatever that underlying policy has. Owner-contractor protective liability insurance is one that is specific to construction projects, and that is an insurance policy for the owner, i.e. school district, which insures the school district against claims resulting from the contractor's negligence, which results in personal injury or property damage. So it's really an overlay of the school district's own commercial general liability policy. The next one is the hazardous asbestos material liability. If you're doing any type of hazardous substance removal, i.e. lead paint, or asbestos removal, the contractor should have this type of coverage in place. And lastly, contractors are typically asked to provide testing services. Sometimes school districts will provide their own testing services for certain types of work. But whichever testing company is engaged directly by the contractor should have an errors or omissions policy. And there are specific requirements for different types of testing agencies that are available and that you can ask your architect or construction manager about, because you want a reputable testing company that you either engage directly or that a contractor engages to meet its obligations under the contractor, who has proper education and professional background. I had a case here on Long Island where the testing company got sued, and it was a testing company that everybody in the world used on the island. And lo and behold, the owner of the company and all of his workers had absolutely no job-specific training for testing. Um, and there are requirements out there that you can use and include in a project manual so that you are ensured that you're getting a testing company that's properly skilled in the types of tests that are being conducted. Nope, I lost my pointer. Again, the prevailing wage rate schedule, it's required to be included in the project manual. One of the interesting things in the prevailing wage rate schedule is it includes a list of contractors who are not permitted to bid on jobs because they've had prevailing wage rate violations. So that's always an interesting list once you receive your bids. I've only once gotten a call from a client where one of the bidders was on the debarred list. And the second is a requirement that the contractor submit certified payroll records with any applications for payment that it makes. And this is not just for employees of the contractor, but also any subcontractors on the project that are using labor. At this juncture, the law only requires you, the owner, to secure those certified payroll records from the contractor. It does not require that you verify that it's accurate. It does not require that you do anything with it except maintain it. However, there are times when there may be a glaring issue on the prevailing wage rate schedule or the certified payroll record. Last week I had a call from a client where there was a blatant misrepresentation on the certified payroll record where the contractor had indicated that it had 10 workers on the site and there were only 2 workers on the site. And I was asked, what should I do? Well, what you should do is don't throw it into the drawer if it's blatant. My recommendation to that client was to call the Department of Labor and alert them that it appeared that there was a problem with a certified payroll record which had been supplied by a contractor. And then the Department of Labor will investigate that. The school district is not going to, start rummaging through the contractor's records. That's really for the Department of Labor to do. But certainly in that case, while there was no obligation on its face to notify the Department of Labor, I felt it was very prudent for the owner to do so. If you've got a flagrant misrepresentation on a certified payroll record, you should absolutely be contacting the Department of Labor for some guidance. The next one on the notable provisions list is this OSHA certification, and this is of very recent vintage from last year or the year before, where if you have a project where the total cost of the project exceeds $250,000, the contractor is required to supply you with certificates for all of its employees on the project showing that they completed at least 10 hours of OSHA safety training. Again, I had a situation this past summer towards the beginning of the school year where a contractor was not providing those certificates, and it was an asbestos abatement project, which was coming up against the opening of school. So, we had a bit of a Hobson's choice. Do we let the asbestos abatement work go forward because it had to be completed before the students arrived, or do we stop the work until the certificates were received? Well, we dodged the Hobson's choice bullet because the contractor, the day that they came to the site, actually provided the certificates. But they should be submitted to you prior to any work starting on the project. And the reason for that is that OSHA has a safety training course for a reason. It's so that employees that work for construction companies know how to utilize proper safety on a project. And that brings me to my next point, which is, and this is not in the AIA document, and again, it is that the contractor is primarily responsible for safety on the project. And as part of the project manual, there should be a provision which requires the contractor to submit a proposed safety and security plan for the project. together with all types of information in terms of how it's implemented, that they are having safety meetings on a regular basis. I think my documents require that it be at least once a week during the course of construction. Very, very important provision or set of provisions, which is not typically found in the standard form documents put out by the AIA. We talked about the submission of equivalents and substitutions. Subcontractors should be required to have a written contract with the prime contractor, and typically I say if the contract is over $5,000, it should be in writing and submitted to the school district. Again, it's kind of a corollary to this one, is a provision that if the contractor wishes to engage the services of a subcontractor, that they should submit that subcontractor name for approval by the owner, you, the school district. And if you don't approve of the use of that subcontractor, that you have the right to say, no, we don't want you to use that subcontractor. Replace the name with another subcontractor at no additional cost to me, the school district. Again, not typically found in an AIA document, but I think it's very helpful. We have a current situation where I've got a concrete subcontractor who is completely unskilled and had no prior experience on the type of project that's being performed. And we said, no, we're not going to accept him. We're rejecting him. Give me the name of another sub. And it's at their expense, not yours. We talked about the SED required provisions in the project. Again, you can find that on SED's website. They actually have a checklist for school districts to refer to make sure that they are in the project. The next one we haven't talked about, and that's experience. One of the things that I find is very important, and we'll get to this a little bit later in the presentation, is the telling bidders what qualifications we expect them to have. And I find that this is most prevalent when you have, for example, a roofing project. Instead of getting a general construction contractor to do a roofing project, it is perfectly appropriate for you to put in your requirements in the project manual that you expect the successful bidder to have roof-related work experience, not just experience in a school district setting or experience on any project, but experience on a roofing project. And that is completely permissible. Typically what we like to see in the project manual is that the bidder be in business for at least 5 years. That shows that there's some stability with the contractor. Secondly, that they've had experience working in a multi-prime environment. We'll get to that a little bit later. Everybody knows the words Wick's Law. And if it's going to be a project where you have multiple prime contractors, you want to see experience from a bidder that they're used to having other contractors on a project, and they understand that the work needs to be coordinated with another entity. Lastly, and again, this is going to sound odd for those of you who deal with arbitration in the labor setting. Arbitration is not the preferred form for disputes in construction. And the reason for that is that typically in the AIA document, the arbitration provision says it's arbitration pursuant to the American Arbitration Association's commercial arbitration rules. That's all fine, except for the panel that you're going to get or the single arbitrator that you're going to get through the American Arbitration Association is typically not owner biased, but rather contractor or architect biased. I have never been in an arbitration setting where the panel, the arbitrator or the panel of arbitrators has any experience being us, being owners. They tend to be contractors, architects, and or their counsel. So I find that it's a fairly biased forum, in this industry, not in the labor industry. And the difference is, as a big parenthesis, is under the labor arbitration rules through AAA, hold on, the arbitrators on the panel are required to be neutral. Excuse me for 1 minute. Sorry about that. Are required to be neutral for at least 10 years. Not so with the construction industry. Most of them are actively practicing attorneys or architects or contractors who have not had that neutrality that is required in the labor arbitration setting. So the preferred method in this instance is court. And if the parties are amenable to mediation, I find that to be a very viable form for dispute resolution. I don't tend to put mediation into the documents because it's something, mediation is the type of setting where the parties have to want to be there. And if it's forced, it's not going to help you get to the next step if in the event that you need to litigate any disputes. Hope I have to get rid of that. Sorry. I did pretty well. I got through about an hour without coughing. Bidding. So now you've gotten your approval from State Ed, your documents are ready to go, and now you're ready to bid the project. The competitive bidding statute is General Municipal Law 103. It requires, if you're just simply purchasing something, that any purchases in excess of $10,000 be bid. So if you're going out and buying equipment or furnishings for a project, if the aggregate cost of those products exceed $10,000, you're required to bid them. Public works contracts, which are in excess of $35,000, are required to be bid as well. And you'll see that I put in red $35,000. And the reason I put it in red is because it's a very new change to the statute. That number used to be $20,000. And in the late fall, the legislature modified that upward to have the threshold be $35,000. So, again, big parentheses, if any of you are in the midst of reviewing your purchasing policies and regulations, this is one of the things that you're going to need to change during your annual review of those policies. Construction contracts are public works contracts and therefore subject to the $35,000 threshold. So, what does it mean to bid a project? First of all, you're required to put a formal advertisement in the official newspaper or papers of the school district. Typically, the official newspapers are set forth and dictated at the reorganization meeting of boards of education. If it's one, you are only required to advertise in one. If it's two, you're required to advertise in both. And again, this goes to timeliness. As you come into and start developing your project timeline, make sure that you take into account when those official newspapers, number one, require the submission of the ad for publication in the next publication. In some school districts, there are local newspapers which are listed as the official newspaper of the school district, and they're only published once every Thursday, and in order to have the ad placed, you've got to have the ad in a number of days previous. So make sure that that is included in your timeline when you're trying to determine when to go to bid. Before I get to the second tab, the law requires that you advertise the bids for at least 5 days. And those are 5 calendar days under the law. However, I always advise our clients you really should not do it any shorter than 5 business days, because if you've got a complicated bid, you want to give bidders the opportunity to review it and come up with a valid price. Typically on construction projects, construction managers and architects/engineers like to give bidders at least 3 weeks to bid, to compile their bid. but I've been in situations where bids have gone out, been submitted and opened. They came in over budget, and then the second time around, it was a much more quick turnaround in terms of advertisement and opening. So it's 5 days. I always say make it the shortest time it should be is 5 business days, even though that's not what the law states. Secondly, the law requires that you award to the lowest responsible bidder, submitting the required security. You don't have a choice. It is the lowest responsible bidder. But there are 3 words in that sentence, and we're going to get to that in a moment. Lastly, General Municipal Law Section 101, which is the sister statute to the competitive bidding statute, also known as the Wicks Law, requires that if you're going out to bid, you must separate from one another the general construction work, the electrical work, the plumbing work, and the HVAC work. Listed HVAC is heating, ventilating, and air conditioning. And there's only one exception to that rule. Again, a new highlight of last year's budget process is that if a project falls below $1.5 million, if you're in Nassau, Suffolk, or Westchester, if you're elsewhere, the rules are different. And I'm going to see if I can find it quickly while I'm talking. But if it's under $1.5 million in Nassau, Suffolk, or Westchester, then you are permitted to do a single prime contract. But there are very specific requirements set forth in 101 Subdivision 5 as to how you solicit bids for a single prime contract. So if you are in Bronx, Kings, New York, Queens, or Richmond counties, it's $3 million is the new threshold. So if it's under $3 million and you're in one of those counties, you are permitted to use a single prime contract. If it's $1,500,000 in the counties of Nassau, Suffolk, and Westchester, as I just said, and if you're under $500,000 and you're in any other county within the state, you are permitted to do a single prime contract. And again, there are very specific items that are required to be included in the bid if you are proceeding with a single prime contract. The most notable of which is that even though it's a single prime contract, the bidder is required to submit a sealed list of bids for each subcontractor that it's going to use on the contract and how much they are going to pay that subcontractor. And once they've been determined to be the low bidder, that list is opened, and they are not permitted to change the subcontractors on that list except in very specific circumstances. So just be careful if you have an architect that's telling you, you can do a single prime contract, and I've had this over the course of the last year over and over again. There is very, very specific language that is required to be included in the project manual. They can't simply say, this is a single prime contract. They have to tell the bidder what the parameters of that single prime contract is. And that's the first step in bidding the project. All right. You've now received bids. They are required to be publicly opened and read aloud. How are you going to award? And I told you I would get back to this. The law requires that you award the bid to the lowest responsible bidder. Again, nice, big, and red, responsible. That doesn't mean the lowest monetary bidder. It means the lowest responsible bidder. And responsibility, this goes back to my statement that you include specific requirements concerning the experience and qualifications of the contractor, because when you include that with your bid, and then you have a bidder that you believe doesn't meet those qualifications, you have a very strong argument that they're not responsible. And I'm going to come back to that in a minute. You'll see the last 2 bullets on the presentation has to do with disqualification. So we're going to come back to if you don't think they're responsible, what do you do? You are permitted to negotiate price down, but only once you've determined who the lowest responsible bidder is. and it's price only. You cannot change the scope of the project when you negotiate a lower price. So we'll follow this through with an example. I've received a bid from a contractor, and I've determined that that bidder is the lowest responsible bidder. And let's assume, for argument's sake, that the bidder is doing cable wiring in a school building, and every classroom is supposed to get 5 cable drops. So now you see his price, and you say, well, it's a little bit higher than I wanted it to be. So you go to the bidder, and you say, listen, can you do any better on the price? And the bidder says to you, well, yeah, I could do better on the price. You know, you've got 5 drops in every classroom. I don't really think you need 5 drops. I think you only need 4 drops. So if we only put 4 drops in each classroom, I could reduce my price by $500,000. You cannot make that change. You are required to negotiate with the low bidder for the scope of work that he bid on. So it's the 5 drops. You can tell him to sharpen his pencil on the 5 drops. You cannot delete work so that your price comes down under this setting in terms of negotiation with the low bidder. There are circumstances where you may be permitted to do a deduct change order along the way, but at the outset, the negotiation of a lower price with the bidder upon award really has to be accomplished under the same scope of work, and that's to avoid favoritism and an unfair advantage to the low bidder, who now has the ability to change things that were otherwise included in the bid and that everybody else bid on, because I could be bidder B and say, well, if you had said that to me, I could have reduced my bid by $750,000, not $500,000. And it tends to invalidate the bid. If you get a bid protest, you will not be successful in all likelihood. And the example that I just gave you is almost the exact facts of a case that I litigated. I actually won in the lower court, where I successfully defended the school district's decision to delete that single drop from each classroom. But on appeal to the appellate division, it was reversed. Happily, the project was completed and nothing came of the appeal, but it is on the books, and it is guidance for you in terms of how to approach negotiation of a lower price. One of the things that I find fault with design professionals and construction managers is the third bullet point on the slide, and that is architects and construction managers, depending on how their contracts are worded, one or both of them really should be doing a comprehensive, thorough review of the bidder's qualifications. It should not just be a review of what they've listed, and architects and construction managers tend to be of the mindset, well, there's really nothing here, I can't find anything. And I've been in a number of circumstances where the school district has called me and said, we just don't get a good feeling about this contractor. Can you look at their bid references? And I actually had a bidder. One of the things that you should be asking for is a list of references from the contractors. And he came up with a list, and something just didn't smell right. So I had the architect in that case do some digging. And it turned out he had left the project off of his qualifications that he was terminated from. And it gave us a great opportunity to disqualify the bidder on the grounds of responsibility, which we'll get to in a minute. But the architect and or the construction manager should be performing a very, very thorough review of the bidder's qualifications in terms of scope of work that they've previously performed. Have they ever worked on a public works project before? Have they ever been in a setting where there's multiple primes? Have they contacted the other architects and construction managers who were on those projects to get a sense from them as to whether or not the contractor did quality work, followed the plans and specs, and completed the project in a timely fashion? And typically what an architect or a construction manager will say is, oh, well, nobody's going to say anything bad about the guy. Well, maybe, maybe not, but at least ask the question. Don't just assume that nobody's going to say anything bad about the contractor. And when you start getting marginal responses, that's when you know you've got to dig a little bit deeper. And we'll get to what you do when you find that you really don't want to award the contract to the bidder. So now we get to disqualification. There are 2 different ways to disqualify a bidder. The first is on the grounds of responsiveness to the bid, and this is the easiest one because it does not require anything except that the contractor didn't do something in terms of its submission that it was supposed to do. For example, most projects require that a contractor provide a bid bond or some sort of bid security with its bid. If the bidder does not provide that bid security with its bid, you have the ability to disqualify the contractor based upon that omission alone. In that case, you can permit him to supply it after the fact. But if you do not wish to do that, you are not required to do that. And you can simply say, I'm sorry, you did not submit the required bid security. You are being disqualified. Another easy one, where you have a bid proposal form, and the bid proposal form has not been completed by the bidder. For example, there is a base bid for the renovation of a toilet room. And the base bid includes 3 different alternates: replace the partitions, replace the floor, don't replace the floor. It doesn't matter what they are. And the bidder does not fill in an add or a deduct price for those alternates. That bid is considered to be incomplete and non-responsive, and therefore you can disqualify the bidder on the grounds of responsiveness, i.e., they did not make a complete bid submission. Very easy. It's done by way of nothing. It's just as a matter of law, they can be disqualified. When you get to disqualification of a bidder on responsibility grounds, you're in a different situation. If a bidder's responsibility is in question, you are required to give the bidder minimal due process. And what does that mean? That means you are required to put the bidder on notice that his responsibility is being questioned for specific reasons: poor work performance, failure to complete prior projects on time, failure to have the proper qualifications to perform the work that you're asking him to perform. And so that's the notice. The notice should say why the responsibility is in question. Second, the bidder must be given an opportunity to redeem himself and say, well, you're wrong. You're reading that wrong. I have these additional documents which will show that I am perfectly capable of performing the work on this project. And lastly, you have to give him an opportunity to be heard, i.e., the ability to submit additional documents, meet with you, that sort of thing. In my life, I like to make that a very, very formal process with a stenographer present, conducted by counsel. The letter comes from counsel advising the bidder that its responsibility is in question. And the reason that I like to, and that is not required by the law, but the reason that is, first of all, money well spent, but it gives you such a wonderful opportunity for success, because one of two things is going to happen. The bidder is going to come in, try to present the documentation that it believes it has, and with a skilled attorney will leave that meeting knowing that there is no way he's not being disqualified. And one of two things will happen. He'll withdraw his bid, which is the perfect scenario for you, is for the bidder to withdraw its bid, because then you don't have to get to whether or not you disqualified them properly or not properly. Secondly, when that type of situation is encountered and you make it very formal with a stenographer present, in the event the bidder chooses not to withdraw, so the board formally disqualifies the bidder, and the bidder sues you, you have a verbatim record as to what transpired in terms of the issue of his responsibility. And it's one of the places, having implemented that process, where I've been very, very successful in either having a bidder withdraw or defending a bid protest where a bidder is questioning a board's decision to disqualify him on the grounds of responsibility. So I tend to like the process to be more formal than the law requires, so that you have the ability to, first of all, document what you've been talking about, but also defend against a bid protest. One of the misnomers out there, and there's one particular architectural firm that gets my clients crazy. Oh, the project's going to be delayed, and there's going to be a stop work order issued by the court, and you're crazy, just award it to them. You know, I've never had that happen. What happens when a bidder goes to court on the issue of responsibility is the first thing they do is apply to the court for a temporary restraining order, which essentially would stop a project. However, if you've set it up correctly and you really do have enough to disqualify the bidder on the grounds of responsibility, that contractor is not going to get a temporary restraining order. I've only had in one place a situation where an architect or a construction manager, I don't remember who brought it to the attention of the district first, said, oh, this guy's horrible, he's going to be awful, we have to disqualify him. We went through the whole process of a responsibility hearing, and at the conclusion of that hearing, I said to my client, you don't have enough. You're never going to get, this guy is experienced, he's got plenty of work experience, he's got nothing bad in his past. If you disqualify him and he takes you to court, you're going to lose. So if you've set it up correctly, you will, for the most part, know if you're going to win or not. So don't be hesitant if you've got a bad gut feeling about a bidder to say, hey, wait a minute, we need to look at this more closely before I award him $10 million in work on a new addition to my existing building, because it's a big project, and you really can have delays or problems along the way. This is the time to fix it. In 9 out of 10 times when I'm called in because a client wants to terminate a contractor who's there already, the first words out of everybody's mouth are, well, we knew this guy was going to be trouble from the beginning. Okay, why did you award the bid to him? You should have never awarded the bid to him. But, there's this feeling that it's this very complicated and unpleasant process, and it really isn't as unpleasant or complicated as everybody would have you think. So that's my little tidbit on disqualification of bidders on the grounds of responsibility. Don't let them push you into a corner because you have no option. There are always options. And the option may not be that you disqualify them, but, it may very well be that you have enough to disqualify them. And don't be, scared that you're going to be delayed submitting a bid on the project. The time for submission of the bid should be and is required to be set forth in the notice to bidders. We talked about the bid security. We talked about making sure that the bidder has submitted a complete bid, and we talked about withdrawal of the bid. I'm going to just touch on one thing in terms of time for submission of the bids. This comes up more times than you can imagine. You've indicated in your bid spec that the time for the bid to be delivered to the business office is 11 a.m. on Tuesday, February 9th. And contractors are a little bit like lawyers. They wait till the last minute, and I've seen contractors running into bid openings as the clock is ticking 11. If the bidder arrives and delivers its bid at the prescribed time in the right place, in the business office, and the bid opening, because the business office is too small, has been moved to the cafeteria, and the business official is not there when the bid arrives, that is a valid bid that needs to be considered. If the bid is not delivered by 11 o'clock, you are not permitted to even open it. So just be careful, because they do tend to run right against that timeline. And there are several contractors across the state who will challenge late bids, that you didn't consider their bid and it was timely. Just be careful that you check with counsel before you disqualify a bidder on the grounds of failing to submit the bid timely. And there we have it. Right on time, 3:15, Donna.
Nice job. Nice job. We do have 2 questions, and I would like Michelle, though, to remind everyone on how you can ask an audio question.
Thanks, Donna. Ladies and gentlemen, for those of you who would like to ask an audio question, please press the number 7 followed by the pound key on your telephone now, and you'll be placed in a queue in the order received. Again, 7 pound to ask an audio question.
Okay, thank you, Michelle. Now, Alicia Coster asked a question.
I see it. I didn't see these come up.
Oh.
Isn't that funny? I see Alicia's question.
Yes, and she wants to know, should your attorney review the entire front-end documents or just the insurance and bid specification language?
The entire front end. And the reason for that is to avoid inconsistency between the notice to bidders, instructions to bidders, general conditions, and Division 0 requirements. They tend to overlap, and you want to make sure, as I said before, say it once and say it well.
I like that. Say it once and say it well. Now, I had a question about those front-end documents. You mentioned something, and I'm not sure I heard it correctly. Was it Division 0?
Yes.
What's that?
Okay. What happens is architects and engineers, everybody's got cheat sheets. And there are what are called CSI divisions, and it's not crime scene investigations. It's contract specification. I forget what the I stands for. And they're set up in divisions. So there's a Division 0, and I'm pulling a spec book as I'm answering the question so that I can properly tell you what Division 0 is typically called general requirements for the contract. And it includes, sometimes architects will put in an index of the drawings, the SED checklisted required provisions, a summary of the work. This one has a multiple contract summary, allowances, unit prices. It's the general overlay of the project, the general requirements of the project. But a lot of times what you'll find in Division 1 are statements that are in conflict with the front end, what I call the front end. Mm-hmm. But at this point in my life, I actually consider Division 0 to be the part of the front end. And what follows Division 0 are temporary facilities, or demolition is usually what comes right after it. And like I said, it's usually a third of the book.
Okay.
Does that answer the question?
Yeah. Well, if not, Alicia will let us know.
Okay.
Now, Kathleen Mullender says, if a district intends to budget for a project in the general fund, is this budgeted as an inter-fund transfer to the capital fund?
It's actually a question for your accountant. Mm-hmm. It's not a legal question. Yeah, as you know, Kathleen, you've got 3 components to your budget: the administrative component, the program component, and the capital component. It belongs in the capital component. I believe that is included within the general fund, but you have to ask your accountant.
Okay. Now, another question that I was thinking of, when it says that the bids have to be in the newspapers that the school district requires, and I know those are chosen at the annual meeting. I'm just thinking ahead here in this technology age that we have. So many newspapers are disappearing. Mm-hmm. Has there been given any thought as to other ways to advertise the bids?
There was at one point some legislation which was in effect for a very short period of time concerning electronic bids, but not formally advertising electronically. So the legislature has not really caught up with technology in terms of permitting the bid advertisement requirement to be satisfied by, for example, posting the bid on your website. Mm-hmm. However, I have a number of districts that do that. They will advertise it in the newspaper, but will also put the bid on their website. Although that advertisement on the website does not meet the requirements of 103 as it currently stands.
Right.
So no, the legislature has not caught up with technology.
Yeah. It'd be interesting to know, as people were accepting bids, how did they find out? How did the contractors find out about it?
And a lot of times you will have somebody ask that question. In terms of receiving bids, they'll do like an exit poll.
Yeah. Yeah. And if we're looking to have that change made, maybe that's some statistical information that could be helpful at some point. Yeah. Certainly lots of little ins and outs and some things that can really cause some headaches. I thought you did a good job with the bidding and how to know whether you have qualified and responsible bidders and how to set up information, and because that certainly could be a headache if it's not done correctly.
It certainly can and has been.
Yes.
And I'm just looking at 103 as we're speaking.
Mm-hmm.
There is a provision that, again, is effective until 2013, which talks about submission of bids in an electronic format. But there is a requirement that the Board of Education authorize that, the receipt of bids in that format. And I have to tell you that, again, there are a whole host of issues with that. It was in kind of a pilot stage a number of years ago. But there are a whole host of issues with how do you maintain the privacy of the bid until the opening of the bids, and that's accounted for in some respect in the statute. But if you're looking to receive bids electronically, please consult with counsel because it's not as easy as it looks. And in my opinion, right now there are enough headaches, as I just described to you, that you don't need to add to your list of headaches.
Yes. Certainly some good examples of information and things that have happened. And we do not have an audio question, and there have been no others that came in. I was just wondering if you had some examples. You talked about the standalone project and attach it to an aidable project.
Mm-hmm.
What can you give us some examples of what you mean by that?
I have a very good example, a very current example. I have a district that is developing and designing an artificial turf field, which is probably going to cost them about $1.5 million. If they were to go out to bid or go to the state with the artificial turf field as a standalone project, submit it as its own project, artificial turf field, there would be no aid for that project because it's considered a site work project. However, what that district has done on my advice is they've taken that artificial turf field project and they have combined it, I believe it's with the renovation of a music room in the building. It's got to be on the same site too. So if you're in a multi-building school district, you can't have, for example, an artificial turf field for the high school and tie that to an elementary school toilet room renovation project. You have to tie it to a project at the same site. So what this particular district is doing is they're taking their artificial turf field project, and at the same time, the base bid is the artificial turf field project plus the renovation of a music room. It's not an auditorium. It's their music suite, I believe. And by tying it with that as one base bid for the contractor to do both of those projects, they will get aid on the full project. And the music room suite renovation, I think, is about, I'm not exaggerating, $50,000.
Oh, my. Well, it pays to know what you're doing and what the ins and outs are.
Your architect and engineer should be telling you all those things.
Thank you. We have an audio question from Stephen Smith. Stephen, what is your question?
Stephen just removed himself from queue. Stephen, if you'd like to ask your audio question, please press 7# again. Stephen, go right ahead.
Okay. With the athletic field example with the bathrooms, or the music room, excuse me, do you need to tell the voters what the estimated cost of the athletic field is and the estimated cost of the music room, or do you simply combine the two together when you present it to the voters?
That's actually a very good question. In that case, it was a referendum, but it was a referendum to expend money from an established capital reserve fund. And so what they did when they got the authorization to expend the money from the capital reserve fund, they had to tell the voters which projects they were proceeding with a specific amount of money pulled out of the capital reserve. And it's a total number. You don't have to itemize how much each of the projects are going to cost if you have more than one.
Okay. Anything else, Stephen?
No, that's it. Thanks.
Okay. Thank you. So anything else that you can think of in this get set period for capital construction projects?
I have a couple for go.
Oh, you can share them with Paul.
That's it. Well, there is one thing that I did not touch on, and that is the use of allowances. And allowances, Allowances used to be the following. An allowance is an amount of money that the contract or the bid documents tell the bidder you must include X number of dollars in the event Y happens. And I'm going to give you the example from the old school. And the example is you're replacing a roof, and there's a wooden deck. The old roofs had wooden decks under them. And there's a wooden deck that is underneath the roof membrane, which sits on top. And because destructive testing of that roof is fairly expensive and would compromise the integrity of the roof that's being replaced, i.e. leaks and whatnot, school districts and architects tend not to do destructive testing of roofs to see what's underneath. So an allowance in the old days would say, contractor, when you submit your bid, include $50,000 for unforeseen conditions related to the roof deck below the membrane. In the event the roof deck is deteriorated and cannot accept a new membrane, we will use this $50,000 allowance money to replace the roof deck. But we really don't know if we're going to use it or not. And typically what happens is if you don't use the allowance money, it is returned by way of a credit change order to the owner. Well, that was many moons ago. And now allowances, or I'm trying to find one, are being used as follows. Include a $50,000 allowance for A, unforeseen circumstances, B, architect error, and I'm not kidding, omissions from the plans and specs, field conditions. And the one that I have a problem with is that, and the one that's open-ended. It just says include a $50,000 allowance for anything in the whole wide world, which is usually used to cover up errors and omissions by the architect. And the reason that it can work for the architect is because the contractor has now submitted a price of $1.2 million, which includes the $50,000. So the board probably wouldn't know in the old days also that it was being used to cover up design errors. But what you should know, and this is really it's partly in get set and it's partly in go. What you should know is allowances should be specific to things like a deteriorating roof deck that we can't see before we design this. And what you should also know is if an allowance gets in without you knowing, and there is an allowance in a project, if any money is to be used from that allowance, it is required to be set forth in a change order. And it's really a no change in price change order. It really outlines how much of the allowance is going to be used and for what. And it's the one thing that in my life makes me crazy when I see. It makes me crazy. I just got one that I just read it to you from a spec book. I mean, really, that's not what they're supposed to be used for. So it's kind of in the get set, but it's partly in the go, because what Paul should be telling you is it should be a change order, because you're using money that technically has not been spent and will be spent in the future, and if it's not spent, we'll come back to the board. And in the most egregious one that I've seen, it was an architect who requested that on each contract, the contractor include a 5% contingency allowance. And it was really to hide his errors and omissions.
Yeah.
And that's what it was used for.
Wow.
So that's my last little tidbit.
Well, thank you so much for all of your information, Mary Ann. We really appreciate you sharing your time and knowledge with us.
No problem. Thank you again for having me.
You're welcome. And for those of you who are going to join us tomorrow for the Stack and Accountability for Parentally Placed Special Ed Private School Students, we'll see you then. And also on Wednesday, we have our March monthly planner on guidance on IDEA billing. So thank you for joining us today, and hope that you will join us either Tuesday or Wednesday or both. Continue to have a terrific day. Thank you.
Thank you very much,
everybody.
Ladies and gentlemen, this concludes today's New York State ASBO webinar. Thank you for participating. Have a great day.